Thank you. Thank you for coming. Really appreciate it. It's really a pleasure to have David Crocker with us. What an opportunity to have him in our Maine community and helping us to address this issue for us. It's a learning experience for us all. Homeschoolers just love to share information. We have a good time sharing information too. We have fun at it. We want to bless our homeschooling community by doing that, but there's a right way to do it and a wrong way to do it. So we are learning. So David is going to tell us more about that. So thank you.
Okay. Well, as Kathy said, my name is David Crocker. I am an attorney. I live here in Portland. I've been practicing now for about 30 years. My specialty and my niche, although I do a lot of general business work, is working with software companies and people in the information technology business. And my practice for 20 years has been very international. I represent people, on the other side of the pond in Ireland and Britain, and, I've seen a good deal of the world doing what I do. In software development, intellectual property and copyright in particular is really wrapped up in it because, as we'll mention, software itself is considered to be a literary work, believe it or not, under the Copyright Act. And so, speaking from the heart, I salute all of you who are heavily involved in the homeschooling movement, and long may homeschooling reign and prosper. I think we all understand what's going on culturally and what's happening in our schools. And it is absolutely vital to strengthen the homeschool movement. And anything that I can do, by way of presentations like this, I am more than happy to do it because I believe so much in what you all are doing. So let's get started. Let's talk about copyright, right? Okay, copyright basics, avoiding the pitfalls. This is for my malpractice insurer. This presentation is not intended to provide legal advice, and no attorney-client relationship results therefrom. Just so you know, lawyers have actually been held to account for kind of what are referred to as curbside consults. A friend says, what about this? What about that? And courts have actually ruled that an attorney-client relationship actually can arise even in sort of casual encounters like that. So I always put a disclaimer in. So let's talk about intellectual property generally, and then let's zero in on copyright in particular. Intellectual property rights are actually recognized in the US Constitution. And if you go to Article 1 of the Constitution, which governs the Congress, Section 8 provides Congress with a bunch of express powers. It's things like declaring war, coining money, regulating interstate commerce, and to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So Congress does have the power to enact various statutes that will protect the creative work of one form or another of people doing these sorts of things. And really there's a very shrewd reason for that. You want people to have the full economic benefit of what they do, because it gives people an incentive actually to create and invent. If there's no incentive, then people aren't going to do the work because very few people are sort of completely altruistic by nature. If you write a book or if you create an invention, obviously you would like to make some money from it. And so this provides a limited time where authors and inventors and others can actually enjoy exclusive rights to the work that they create. Now, over the years, Congress has enacted various federal statutes addressing intellectual property. The three chief ones, however, are patents, copyrights, and trademarks. The Lanham Act, which is what is the Trademark Act, it regulates the registration of distinctive marks associated with specific goods and services. This is done through the United States Patent and Trademark Office. It covers the entire United States, and it covers all goods that are in interstate commerce within the United States. Patent Act regulates patenting of various inventions. That's what are called utility patents, plant and biological engineering, and designs. Now, an easy way to think about patents is that a patent protects basic ideas for a limited period of time. And for a patent to be granted, an invention must be useful, novel, and non-obvious. Now, it's way more complicated than that. I'm giving you the matchbook, back of the matchbook summary of the whole thing, just so you understand where copyright falls in the spectrum of legislation that the Congress has enacted. The Copyright Act, which is found in 17 United States Code, and by the way, all of the laws that Congress enacts are codified, meaning that they are put within one of the titles of the United States Code. And by the way, if you wanted to see what was in the United States Code, there are websites where you can access that. One of the best ones that I've used over the years, I actually use it as a homepage in my web browser, is Cornell University Law School's Legal Information Institute. And they have a wonderful collection and access to federal materials, including the US Code, Code of Federal Regulations, court cases, everything else. So the Copyright Act is found in Title 17 of the United States Code, and it protects original works of authorship. Keep that phrase in mind. In contrast to patents, which protect ideas, copyright protects the expression of ideas. And hold that thought, because that's what distinguishes copyright really from patent. One is ideas, the other is expressions of ideas. Now, copyright protects various forms of authorship, and most people are actually surprised to learn all of the different things that can be subject to copyright. Literary works, huge variety of things: fiction, nonfiction, poetry, textbooks, reference works, directories, catalogs, advertising copy. Yeah, you write a jingle, you write some advertising copy. You bet. Of course, it's original. It's subject to copyright. Compilations of information. A compilation is actually a work that is created out of various other works. For instance, if you buy a literary anthology, that would be considered a compilation. You have an editor or editors who actually choose what works are represented in the anthology, how much of those works, all put together into a compilation. Computer programs, believe it or not, are considered literary works. Source code is written in a human readable language, and you can register the copyright on them. There are ways to do that. And believe it or not, automated databases. And we'll get to this in a minute when we talk about originality, but even databases can be subject to copyright. Now, works of visual arts, and that can be anything pictorial, graphic, sculptural, 2 or 3 dimensional works of fine art. So you have, reliefs, various forms of sculpture, fine art, graphic art, applied art, photographs, prints, art reproductions, maps, technical drawings, architectural works. Yeah, you create blueprints or schematics or anything like that. Yeah, absolutely subject to copyright. Architectural drawings, absolutely. Architectural renderings, all of those things. Anything that has creativity. Works of the performing arts, musical works with or without lyrics, dramatic works, such as screenplays, a play or other script, a pantomime, choreography, dance, actually, can be registered as a copyright. Sound recordings, these can include underlying musical, dramatic, or literary works that are embedded in the particular recording. because understand that not every single work that's subject to copyright is all of one thing or the other. Sometimes you have a mixture of different elements. You have visual, you have auditory, musical, literary. I mean, it's a huge mix. Motion pictures and audiovisual works. These include feature films, documentaries, animated films, television shows, videos, video games, any other audiovisual work. And just so you know, the definition of an audiovisual work is a work that consists of a series of related images that are intended to be shown by the use of a machine or device together with accompanying sounds, if any. So here we're talking about things like video games and anything that you can run as a recording through your computer that is both visual and, for the most part, auditory. So let's get back to this phrase, original works of authorship. First of all, a work to be subject to copyright has to be original. There has to be some modicum of creativity. And now the threshold actually is fairly low. For instance, there's some works, such as databases, where creativity is expressed by arrangement of unoriginal elements. Now let's talk about that. What do I mean by that? Well, databases usually have data points, the datum that actually go into the database. The datum themselves would have no originality. It's just a piece of data or data. And the datum itself would not be subject to copyright. But if you take all of those unoriginal elements and you arrange them in a particular way, then yes, the arrangement, the structure, all of that actually can be subject to copyright. To give you an example, there was a court case back in the 90s. The name frankly escapes me. Back when there was shrink wrap software, you might recall that you could buy a CD with basically everybody's phone number in the United States. So you had entire phone book database of basically every human being within the United States. And what somebody did was they took that, bought the CD, and they simply extracted wholesale all of that data and started using that data. And it went to court, and the court finally found that there was no infringement because they weren't using the structure of the database. They were just using the data points that were contained in it, which of themselves would not be subject to copyright. Now, it actually has to be a work. It has to fall into one of the categories that we just described: literary, audiovisual, what have you. And there has to be authorship involved. There has to be a human author who exercised some level of creativity. Now, understand that authorship really is a term of art. It's whoever holds the copyright, yes. We'll get to it in a bit, the problem of employees and works made for hire. Generally speaking, the person who actually creates the work is the author. However, there are some situations where that is not the case. And we'll talk about that in a moment. Now, when does copyright arise? And the answer to that is automatically. Whenever the work is fixed in tangible form, you don't need to register the work with the Copyright Office. And oh, by the way, the Copyright Office is a part of the Library of Congress. You can access it online. So it exists there as a division of the Library of Congress. You can register copyrights, but copyright arises automatically when that work is fixed in tangible form. So if it's a literary work, when you commit it to a piece of paper, or again, the threshold here is low. For instance, it's been held by courts that writing contained in computer random access memory is considered fixed for copyright purposes, even though when you switch the computer off, the random access memory clears out. So it's a fairly low threshold, but there has to be some fixation, there has to be some tangible form. Now, you can register the copyright even though it arises automatically. And why would you register the copyright with the Copyright Office? Well, it's necessary to access federal court to sue for infringement and to receive various remedies that the court can provide. Now, how hard is it to register copyright? The answer is not particularly hard. It's not like registering a trademark. Registering trademarks, actually, there's an extensive examination process where there's an examiner in the trademark office, and your application can be rejected for various reasons, and it's a fairly complicated area of the law. But registration in copyright is really a ministerial type of act with a few very, very narrow exceptions. Basically, you fill out a form, which you can do online now, and if the work is published, you're going to always, published or unpublished, you're going to have to, there's what's called a deposit requirement. You actually have to provide a copy of the work for filing in the Library of Congress. So the Library of Congress has this gigantic warehouse of all the deposits that come in with copyright registrations, books, unpublished manuscripts. I mean, on it goes, musical scores, computer programs, what have you. But there is a deposit requirement, and the actual cost to do it is pretty low, pretty affordable. So how long do copyrights last? And for works, the law is constantly being changed, and it has been over the years. In 2002, the Congress passed what was called the Sonny Bono Copyright Extension Act, named after the late Sonny Bono. And for works first published after 2002, 70 years after the death of the author. And if there are multiple authors, then it's 70 years after the death of the last author listed. Now, in cases of corporate authorship, and this has to do with employees, for instance, working within the scope of their employment, we'll get to that in a moment, it's 95 years from publication or 100 years from creation, whichever expires first. Now, what is publication? Publication is defined in the Copyright Act as whenever you have something that you either sell or transfer ownership in. That means if you have a book, you sell it. If you have some kind of, I mean, it can be sold, it can be leased, it can be given, it can be, if it's a work of visual art or sculpture, a public display, anything like that is considered publication. Now, who gets to control the copyrighted work? Well, with a very few exceptions, copyright gives the author complete control over the work's use, publication, and distribution. Now, 105, Copyright Act Section 105 permits the author, and again, here are some of the categories, to control reproduction, preparation of derivative works, performance of dramatic musical sound recordings in public, and public display of visual works of art. So there is this huge element of control that is given to the author to control how that is, how the work is performed, displayed, reproduced, what have you. Now, let's talk about very briefly what's a derivative work, because that's something that comes up. A derivative work, as defined in the Copyright Act, is a work that's based on another work. So an example of a derivative work, the simplest one that everyone can grasp, is a translation. If you have a work in English and you translate it into another language, that's a derivative work of the underlying work. So it's based, it's a new work, but it's based upon somebody else's work. And it is also subject to copyright, but you would need the author's permission of the underlying work to actually publish that derivative work. And there are other ways to create a derivative work, as you can imagine. You could take a photograph, for instance, and modify the photograph, or I mean, on and on it goes. There are different ways to make derivative works. But the control lies ultimately in the author to control the reproduction and preparation and performance and public display. Now, copyright is actually a property right. So, you know, if you own your house, you have a bundle of rights in your home and the land on which it sits. And, you know, you've heard of things called easements and profits and rights of way and things like that. These are all increments of ownership that the owner of the property can actually deed to someone else. Well, copyright is sort of the same way. There's a huge collection of rights that are contained there. And if you license it, the nice thing about licensing is it's transferring a right to somebody else without transferring the underlying ownership. And you can license something, you know, as thin or as fat as you want. You can, for instance, license a musical work or dramatic work to be performed one time at a particular place. You can, again, you can slice the bologna, so to speak, just as thick or thin as you want. So if the author has such control over reproduction and preparation of derivative works and the like, is there any kind of use that can be used, you know, can be undertaken without requiring the permission of the author? And this is the whole subject of what's called fair use, and you may have heard of it before. That is in Copyright Act Section 105. And actually, it's worth looking at the whole section, and we can look at it and read it together. And I need to move there you go. All right. So notwithstanding the provisions of Section 106 and 106A, 106A basically covers the exclusive rights. 106A covers certain exceptions where an author can be, his work is attributed to him even if he doesn't own the copyright. So fair use of a copyrighted work, including such use by reproduction in copies or phonorecords or by any other means specified by that section, for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use. You know, we were all in college and we were all assigned stuff we had to pick up at the desk, you know, the circulation desk in the library, and read and then return it, right? Like a journal article or something like that. So multiple copies for classroom use, scholarship, or research is not an infringement of copyright. But there are a whole list of facts and circumstances that have to be determined to determine whether it falls within this exception. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. For instance, if I were writing a book and I wanted to extensively quote another author, naturally I would have to footnote his work and put it in quotes, but I would also have to get permission from the author or publisher to extensively cite his work in my own. That's a work of a commercial nature. However, if it's an educational type of use, probably not. The nature of the copyrighted work, well, you know, if it's something that is in the public domain or the only copyright that exists is the publisher's copyright because of the edition, you know, there are all kinds of factors that go into determining that nature. The amount and substantiality of the portion used in relation to the copyright work as a whole. In other words, if you're just taking a snip here or a snip there, probably not a problem. However, if you're basically wholesale copying or reproducing the whole work, then you really have to determine why you're doing it and what the purposes are. The effect of the use upon the potential market for or value of the copyrighted work. Well, yeah, if you're doing wholesale copying and passing it around, even in an educational environment, then people aren't going to buy the book. So, keep that in mind. Now, the fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. Think about it. If an author has an unpublished work that's never changed hands, it's always resided in the author's hands, but he might have shown the work to somebody, then it isn't necessarily an infringement to use a portion of that work. However, it's subject to all of the factors that are outlined in Section 105. So as you can see, yeah, fair use exists, but as they say, every situation is different. And so you really have to judiciously weigh all of the factors that go into your use of a work under fair use. I will tell you that the safest approach is always to ask permission. That's my advice. So infringement is violation of Section 105 that falls outside of fair use. And in close cases, there's going to be litigation, or there may well be litigation, or at least a stink of some kind. Because you have to weigh and measure all of these facts and circumstances. They all count. Now, recall that copyright protects the expression of ideas, not the ideas themselves. Authors reuse the same plot concepts over and over again, and whether it's infringing actually is based upon how close the copying is of the actual work. Now, let me give you an example, a famous one that they always recite in law school. There was a very, very popular stage play in the 1920s by a woman named Anne Nichols. And it was called Abe's Irish Rose. And the subject matter of the play, it was a comedy, and it had to do with interracial marriage between a Jewish man and a Gentile woman. And they married against the will of both of their families, and all of the comedic aspects of that relationship and all of the troubles, joys and troubles that came from that clash of cultures. It was a very successful play. It was turned into, Abe's Irish Rose was actually turned into a motion picture in the 1940s. But the concept of interfaith marriage is something that you see over and over again. And so there was litigation over this. Universal Studios, again in the 1940s, produced a film called The Kellys and the Cohens, or The Cohens and the Kellys, I can't remember which. And the author of Abe's Irish Rose, Anne Nichols, thought that they were ripping off her play. And so she sued Universal Studios, Nichols versus Universal Studios. And after it went through considerable litigation, it was determined that there was no violation of copyright, because really what was being shared here was the concept, was an idea, not the expression of the idea. And so you see various shows from time to time that deal with interfaith marriage. If you're a bit on the older side like I am, you remember a 70s show with David Burney and Meredith Baxter Burney called Bridget Loves Bernie, I think was the name of it. Was that it? I think. Yeah, and it's, Gentile woman marries, Irish Gentile woman, Irish Catholic woman marries Jewish man. So sound familiar? Well, there wasn't litigation this time because, again, you're recycling an idea, but you're not actually ripping off the literal words, or you're not getting too close to the sequence of ideas contained in the text. Now, this has to do with many other things, not just literary. I mean, for instance, many photographers take pictures of, say, roses, but the rose is the idea, but no one's going to claim that you can put a copyright down on all photographs of roses. There's creativity that arises in every single case. You know, photographers do the lighting and the color and the arrangement and all the other things, but it's still a rose. So understand that whether or not something is infringing is based on how close the copying is of the actual work. And, you know, wholesale copying or plagiarism, of course, is never acceptable. And you can actually have a finding of infringement in a plagiaristic concept where there may be no literal copying, but the plot outline is so close to another work that it's deemed to be infringing. So this, you know, you see this in music. I mean, there was a case dealing with some band sued Led Zeppelin because they claimed that a particular riff, you know, in Stairway to Heaven, you know, was borrowed from, you know, one of their musical works. After years of litigation, it was found that this is not the case, but these things do happen. So if you are in doubt, you need to get permission for use of a copyright material, and it's necessary with some kind of rights license, whether it's paid or unpaid. I mean, most of the time, for instance, authors who quote other authors, unless it's not wholesale copying, it's usually a matter of just getting permission from the publisher and author with attribution. And it's not necessary to pay anything, but what you receive in effect is a license. So, and again, to the performance side of things, you probably heard of an organization called ASCAP, which is the American Society of Composers, Authors, and Performers, I think. And, you know, bars that run Muzak with, you know, various musical works, all of that are supposed to pay license fees to ASCAP. ASCAP being a universal clearinghouse for performance licenses of artists' music. So let's get to the whole idea of works made for hire. And that gets back to the whole question of ownership. Now, works made for hire is one of those kind of muddy areas where you really have to ask very, very strict questions. And generally speaking, all right, when employees create work subject to copyright, the employer is the author. And the caveat here is that the work that the employee creates is, it has to be done within the scope of that employee's employment. So for instance, if you are a software developer working for a software company, if you created some kind of software program that was, you know, something that the employer would be very interested in, or it's something that would benefit the employer, was within the same market as the employer, could possibly compete with the employer, would interface with existing works of the employer, then probably it's going to deem to be within the scope of employment, and the employer, not the employee, is going to be the author. All right. If the employee was, let's change the facts a little bit, or a lot actually. If the employee was a software developer, but he or she wrote a novel, it would not be within the scope of employment, and there would presumably be no issue. So let's talk about non-employees and the whole idea of contractors creating work on a commission basis for someone else. In those cases, the contractor holds the copyright, believe it or not. Now, if you hire me to paint your portrait and you pay me a ton of money, well, guess what? You get the picture, right? You get the canvas, you get the paint, you get the literal work itself. but I, as the artist, have the copyright. And you think, well, that's kind of strange, isn't it? Because somebody is paid for that, and yet the artist retains the copyright. Well, that's a fact. There are some exceptions, some very arcane exceptions to that. Most of the time they don't fit, so I won't even bother with them here. But anytime that you have somebody who's doing work for you, always ask the question, are they an employee or are they a contractor? Now, frankly, even somebody who's an employee, if they're going to be doing creative work for you, they should sign a short form employment agreement that provides that any work that they do within the scope of their employment is going to be assigned. That's the word, the fancy legal word for given or transferred to the employer. That's done as an insurance policy. You know, the software company that I'm general counsel for, you know, we have 120 employees worldwide. Believe you me, every last one of them signs a little employment agreement where all of the work that they do in the course of their employment actually belongs to the company, and they assign it to the company. We're not going to rely upon the vagaries of the work for hire rules. We're going to actually have a piece of paper that says that they actually assign it. Absolutely, if somebody is a contractor and not an employee, you should have an assignment agreement for anything that you commission them to do. There was an important case in the 1990s. It was decided at the US Supreme Court, Community for Creative Nonviolence versus Reed. You may recall from the 1980s, there was a homeless advocate named Mitch Schneider, a rather kind of troubled person. But the organization that he worked for, they actually commissioned an artist to create a sculpture of a homeless person. And guess what? There was no assignment agreement, nothing at all between the artist and the nonprofit company, corporation. Went all the way to the Supreme Court. Supreme Court said, they actually upheld the work for hire rule, that the contractor would actually own the copyright in the first instance, but they actually sent the case back to the lower court for a factual determination as to whether that artist was an employee or a contractor. So always remember that. If you commission a work from somebody who's not your employee, you need an assignment. Even if the person is your employee, get an assignment. That way you sleep much better at night and you don't wake up at 2 o'clock in the morning and with a cold sweat saying, do we really own that $1 million piece of work? So, you know, the thing that I've heard many times over my career is this wail, but I paid for that. The painting, photograph, sculpture, dramatic work, ghostwritten work. How can I not own it? Well, I didn't make the law. Take it up with Congress. It's always necessary to assign the work to the person commissioning, paying for the work. So let's talk about infringement. We've talked about direct infringement, okay? But you can actually indirectly infringe somebody else's copyright. And there are two types. There's contributory infringement and vicarious infringement. Let's talk about the two of them. The person who's not the actual infringer can still be liable for infringement. There are two elements. The defendant has knowledge of a direct infringement and the defendant materially contributes to that infringement. This is the case where you know, somebody actually has knowledge that infringing material, that they're handling infringing material, and yeah, they contribute to it in some way. I mean, for instance, they make copies, they create a forum online where it can be distributed. You know, any number of things where the defendant materially contributes. And understand that It's if you moderate a public forum and you put on notice of possible infringement, then by all means beware. And let me just back up here. You don't need any kind of financial benefit here. The infringement is enough, all right? So the defendant who materially contributes to the infringement, they don't have to be getting anything out of it other than the joy of spreading somebody else's work around. Now, what's vicarious infringement? Well, it's another form of indirect infringement, two elements again. Defendant have the right to control the infringing activity. You don't even need to have knowledge of the infringement. So you have the right to control the infringing activity, and the defendant derives a financial or commercial benefit from the infringement. Now, what would be a good example of that? Well, if you remember back in the early 2000s, there was a peer-to-peer music sharing company called Grokster. How many of you remember Grokster? Kind of raise your hand. No? No? Okay. Well, at the time that Apple Music and all the others were, putting together download services, kind of the precursor to that were peer-to-peer sharing services, and Grokster was one of them. Basically, it worked like this. Grokster owned a sharing site, and what you would do is you would rip tracks from your CDs and you would upload them to Grokster. And then somebody could go on to Grokster and they would go through the library of all the stuff that was there, and they would download it free of charge to their computer. So people were, quote, sharing their music. Well, there was not necessarily any money changing hands. Grokster made a lot of money because people advertised on the site, so they were doing quite well. And there were other ways that they were making money. The people sharing their music weren't exactly making out, but they were actually infringing the copyright of the recording company and or the artist. And there was a direct financial and commercial benefit from the infringement by the defendant, in this case, Grokster. Although the recording industry actually started suing all of the people who uploaded music. And we'll talk about statutory damages here in a moment. As I mentioned at the outset, a finding of vicarious infringement can be imposed without an actual knowledge of the infringement. Although in the case of Grokster, they had to know that the music was infringing because it was all taken from, there were recordings, made in a recording studio by a recording company, probably ripped from a CD and then uploaded to their library. So I'm not sure how you play dumb in that particular situation, although they tried very hard. Well, before we do that, let's talk a little bit about, and I didn't put this in the form of a slide, but let's talk very, very quickly here about what damages and other remedies are available to you if you were to sue somebody in federal court. First of all, as I mentioned, you need to register your copyrights to get into federal court and to get these remedies, but you can actually obtain injunctive relief, which is to prevent somebody from continuing in their infringing behavior. You can also get actual monetary damages and any lost profits to the extent that they can't be recovered by way of direct damages. And if the damages aren't all that great, you can go for what are called statutory damages. And there's a maximum and a minimum involved, and where the actual dollar value of infringement is relatively low, a lot of times people will try to go for statutory damages because they can actually, get some kind of money out of the infringer. Like I said, all the people who were uploading their pirated music to file sharing services, they went after, the recording companies actually went after a lot of them for statutory damages. So there are various remedies involved. Again, it involves litigation. You can recover attorney's fees and costs in most cases. So it's not a place that you want to be. All of this takes place in federal court. Federal court is not a place that you want to be. I don't want to be in federal court, and I'm a lawyer. So that's really about it. I mean, that's the thumbnail. If you want to learn more about this, I would say go directly to the Copyright Office. You can Google it. They have splendid publications, dozens and dozens of them, basically covering every aspect of copyright and every type of work. And they'll talk about, I mean, there's the very first one, they call them circulars, copyright circular. Number one is called Copyright Basics. It's been called Copyright Basics for forever. And it is a great thumbnail sketch of all of the statutory elements and everything you would probably want to know about copyright. And then if you want to go into things in considerably more detail, there are umpteen, I mean 100 or more circulars that are there available free of charge for the taking, covering just about every subject that you can imagine. There are also books that you can buy commercially that, you know, is copyright for lay people or copyright for various things. For instance, if you were doing multimedia work or motion picture or some kind of production where there are different types of works involved, music, audio, literary, you know, all of the different things that go into that type of endeavor. You know, there are ample resources for that as well. Although if you were going to do something like that, I would say it's worth your time to hire a decent lawyer who knows that whole area. Well, I thank you for letting me come into your home. I'm always grateful for opportunities like this. And like I said, you know, keep up the good fight in the homeschooling movement. And I hope to see all of you again.
Thank you, David, very much for spending the time. And that was a lot of information, I know, to take in one sitting. And if you do have questions or anything that you want clarified, just shoot me an email and I'll get it to David.
Okay. Thank you, everybody. Have a good evening.
Thank you.